If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid with Florida estate planning attorney Andrew Rosenberg. Andy helps South Florida families protect their legacy and avoid legal chaos and build plans that actually work when life gets messy. I'm Lisa Mosby, your host, and today we're talking about funding your trust. Creating a trust is great, but if nothing gets moved into it, it won't work. Andy, are you ready to go today?
Oh, I can't wait to talk about this topic today, Lisa. Holy moly, this is so exciting.
So, Andy, tell us, what does funding a trust mean for families in Florida? Actually, for probably every state in the union.
It's for every state, yeah. Obviously, I'm down here in Florida, so I'm talking about Florida, but I'm sure it applies to every state. So a couple things. People don't understand trusts, and I get that. It's complicated, okay? My trusts are 50 to 70 pages long. It's a lot of legalese. And by the way, if you ever can't sleep at night, I tell my clients, pull out the trust, start reading it. If you get past page 5, you're doing great because you'll fall asleep. It's just not exciting stuff, but it's very important, but it's not exciting. But there's 2 steps, and we talked about this in a prior episode, but I just want to reiterate the process so that people understand it. There's 2 steps, guys, to a trust. You got to first create it, witness it, notarize. You got to create the damn document, guys. All right. That is step 1. At that point, think of it as that empty box. But if you don't do step 2, you're wasting your time. And as I like to say, if you don't plan it right, you're stupid. Okay. You're being stupid. You're paying money for this thing. Have it work right, guys. You got to do the second step. The second step, the legal term, is called funding or populating the trust. That's a fancy legal term for basically filling up the box with assets. If you fill the box up with the assets, when you pass away, it's going to go exactly how you want it to go. No probate court, easy peasy, done. The problem is, Lisa, it's never, ever works out that way, unfortunately. People just don't do it. So what did I do? Listen, I got tired of people coming to me when the spouse or family members die, and then they come and they say, okay, is everything in the trust? And they say, what are you talking about? And they have like 2 or 3 assets that are titled properly in the trust. Everything else is in the person's name when they died. I said, we got to do trust administration, and now we have to do a probate administration. I said, we defeated the whole purpose. I got tired of that. So you know what? So I said, I'm going to add a service to my office. So I tell people, listen, if you don't do the second part of funding, you're being dumb. And it's okay if you want to be dumb, but don't be stupid, okay? And so we offer trust funding services. We will help you fill up that box by having my paralegal help you with the process. We're going to charge for that, but we do offer it so that we make sure that at least if you want it done and you're not sure how to do it, that my office will help you go through that process to get it done so that when you do pass away, there's no issues with the family.
You'll save all the money on the front end or on the back end, right? You'll have it done so that you'll save all that money. Whatever it costs you, you'll.
Yeah, both. I mean, it's not a lot of money to do it. Yeah. But the back end, listen, guys, probate's not fun for anybody. I don't like doing them. I mean, I do because I get paid a lot of money, so I like that. But I feel bad because it's a nightmare for everybody, and I feel bad for the family because it's not fun to go through. So if you've planned for everything and you've done the trust, you did everything, why don't you do it, make it a touchdown and finish it, right? Get the trust funded.
So let's talk about what kinds of assets need to be retitled. We think of the house. When we think of a trust, the house is in there. But does the car go in there? What other things? We know your retirement account might be going in there. But what assets need to be retitled or reassigned to make sure that the trust is working properly and you can avoid probate?
Yeah, that's an interesting question. So we're gonna tailor this more to Florida for a minute, okay? Because Florida has a special kind of deed for houses. Okay, for any real estate down here in Florida, we have something called a Ladybird deed. And there's only 6 states that have it. Florida's one of the 6. So I do a lot of Ladybird deeds when we have a trust. And so here's how it works. Lisa, let's say that you own a property here and that you have a trust down here, etc. And the property is in your name alone. So what I want to do is I got a deed here. It's in your name alone. I want to create a new deed over here. I'm trying to do it on camera. It's not easy. Over here, transfer the property from you to you. So it's still in your individual name. So it's not in the box, but it's still in your name. Still have homestead rights. It doesn't change any of that. Everything stays the same. No changes in your taxes, real estate taxes. Everything's fine. But this new deed we created, when you pass away, it names a beneficiary on the deed. And the deed says that it goes directly into the trust. So it avoids probate when you die because it automatically goes into the trust. It's called a Ladybird deed. Only 5 states have it. So real estate, obviously, if you have real estate in Florida, we want to try and do that Ladybird deed where it makes sense to take care of it and to make sure that that's taken care of. If you have real estate in other states, then we're probably going to want a direct transfer from your individual name to the trust name. So that's a distinction on the real estate side. You asked something interesting, by the way. You said we got real estate, we got investment accounts, we got retirement accounts, we got vehicles, and vehicles is always a touchy subject. This is like a personal thing, I guess. As an attorney, I personally tell clients to leave the vehicle as is. Don't worry about it. Keep it in your individual name. I think it's easier that way. Now, then you may say, well, Andy, if I die, it's in my name. Isn't that going to go through probate? And technically the answer is yes, because it's in your individual name. However, Florida, I've been doing this for a long time. I've yet to have an issue where if you have just the car and it's in your name, go through the probate court. Because what happens is, as long as you have a death certificate and we have a valid will, it's important to have a will, and we'll talk about why you need a will with the trust. And you have a valid will with the death certificate, if you take your will with the death certificate to any Florida Department of Motor Vehicles and show that to them, they'll fill out paperwork and they'll transfer the title to wherever the will says it needs to go. So that's why I kind of keep the vehicles as is, but everything else it needs to be dealt with. So bank accounts is an interesting topic, okay? I mean, I don't want to get it too confusing, but I like to keep assets in Florida. There's creditor protection, right? Everyone's concerned about being sued. So a lot of times I want to keep the assets in husband's and wife's name together because it's called tenancy by the entirety. If you have an asset together with the husband or wife together, it's like joint ownership with rights of survivorship, but between a husband and wife. It's a special form of ownership. And that's actually creditor protected. So imagine if, Lisa, you and I are married. We're not, Debbie, but imagine we were, okay? My wife would not be happy. So you and I are married, and we have a bank account, and it's joint. It's held together as husband and wife. That's tenancy by the entirety, okay? That's the legal term. If I got in a car accident, and it's my fault, and they want to sue me, they couldn't come after that joint bank account because it's held by husband and wife. It's protected. You and me would both have to be sued for something to be able to deal with that. So I like to keep assets usually with clients when they come in. If they are married, I try to keep them as husband and wife for that creditor protection reason. But with bank accounts, I try to make sure that they go and have a TOD or a POD made to the account. So keep it as husband and wife, but have a TOD or a POD, stands for transfer on death or payable on death for bank accounts. It's basically a beneficiary to the bank account, and just name your trust as the beneficiary on the account. By doing that, we're protecting you as husband and wife by keeping it as husband and wife ownership for lawsuit situations. But if you both pass away, it will go automatically into the box, no probate. Did that make sense?
It does. And I've gone through all of those things, so it's crystal clear.
Okay, good. So vehicles, I don't recommend. I think you're fine. Just keep it like that. Real estate, you now know Ladybird deeds in Florida if you can. And then elsewhere, you should do directly. Bank accounts, I'd like to keep them in your name still, if possible. There's another advantage, by the way, to keep it in your name. Imagine if we said we need to do a new bank account in the name of the trust, and we put everything into the trust name, which is fine, by the way. But when you do that, you're going to have a new bank account number, which means that you're going to need to get new checks issued and everything else. So it's kind of a pain in the ass. So if we can avoid that, why not? So that's why I also like to do the TOD or POD. Now, IRAs and 401ks are different, okay? Because if you change the ownership of an IRA or a 401k and make the trust the owner of it, you're going to get screwed because they're deferred accounts for tax reasons. An IRA, individual retirement account, a 401k is a deferred vehicle. We put pre-tax dollars in, and then when we need to take it out when we're older, you get hit on the tax on the out when you take it out. If we immediately transferred ownership of those vehicles directly into the box, they're immediately going to get taxed 100%. So never, ever transfer IRAs or 401ks ownership into the trust. What do? You change the beneficiary form. That has a beneficiary form, right? An IRA or 401k. I always make the primary beneficiary a spouse if you're married, and the contingent or alternate beneficiary the trust. By doing that, we're avoiding probate. So if your spouse survives you, it automatically goes to the spouse, and there's tax benefits to that. If your spouse doesn't survive you, and now you pass away, well, we have an alternate beneficiary. It's the trust. It goes into the trust, no probate. How's that? Make sense?
It makes sense. I'm going to throw one out there, the annuities. We know people that have annuities. Is that in the same category or is that something different?
Yeah. So general rule, I like to say IRAs, 401ks, life insurance, annuities. They all have beneficiary forms. Keep the ownership the same. Make the primary beneficiary your spouse. Make the contingent beneficiary the trust. If you're not married, make the primary beneficiary your trust. Got it?
Okay, that's clear. And for someone who's already created a trust, what are signs that it might not actually be funded the way that they think it is? Or can they meet with you to find out if they have everything in order? What are their next steps if they already have a trust, but all this stuff is new to them?
Yeah. So the best way to do that is to look at your statement when you get it. Usually if it's in the trust, okay, if it's titled ownership in the trust, you're going to get a statement, and it's going to say, for me, it would say, Andrew Rosenberg, trustee of the Rosenberg Trust. So now you know, obviously, it's in the trust and what the investments are. You're not going to know that, though, with IRAs, 401ks, life insurance, annuities that have beneficiary forms, or the bank accounts that I tell you to keep in husband and wife name and do a TOD or a POD. You're not going to know, right? Because it's going to show up when you get the statement in your name alone. So what you need to do is you need to periodically get an update request of what are our beneficiary designations and just verify how they're set up. And that's part of what I do when I meet with clients is we ask them, when's the last time you looked at your beneficiary designations? Are they in the trust name or not? And half the time they're like, what the hell are you talking about? And I say, well, there's 2 steps, like we talked earlier in the podcast. You got to fill it up. That's that second step. And they're like, oh my God, I don't think we've done that. So that's what needs to be done. Again, guys, you got to remember, okay? We're talking about boring stuff. I get it. However, this is really important stuff. If you need to update your documents. You need to review your documents at least every year and a half, 2 years. You need to meet with somebody to make sure that the beneficiary designations are up to date, to make sure that the title of the assets are in the trust, to make sure your trust is updated, okay? Life changes. Listen, you may give something to a friend of yours when you pass away, a percentage of the estate to a friend or to a niece or a nephew, and you're no longer talking to them. A year and a half later, you're pissed at them. Well, guess what? We need to change it. We need to do an amendment to the trust to fix those things. So remember, all this stuff, it's dynamic. It's not static. You don't just set it and forget it. You got to continuously look at all this stuff.
You took the words right out of my mouth. I was thinking this is not a set it and forget it item at all. So how I want to wrap this up is once a trust is funded, how do families keep things up to date when they say buy a new home or they add new accounts or maybe even they refinance their home and the house has to come out of the trust and go back in? There's some of these unique nuances that happen.
Yeah, that happens a lot. I hear that a lot. My clients call me and say, listen, we're going to refinance, but they won't refinance it in the trust name. I'm like, yeah, I get it. So we have to do a new deed, transferring the deed back into their individual name, right? Then they refinance it. And then we talk to the refinance company, make sure it's okay. And then we do a new deed back into the trust. So you got to take care of that. So that's really important. What was the other question? I forgot. You wanted me that. Oh, when you buy new stuff. The hard part, think of the trust. I like to think of the trust this way. Think about it. When you create a trust, think about that you've died, okay? So from everything you bought before until the trust is created, you're doing a probate while you're alive. Think of it, because the probate is when someone dies and they have assets in their name, we have to go through that whole nightmare court system to get it to wherever it needs to go in the will, right? That's probate. But if you don't have a will, the state of Florida decides what's the statute. So when you create a trust, think about all the assets that you built up and you own all the way up to the date of the trust. You're really doing a probate while you're alive, because what you're doing is you're transferring assets of everything that you have in your name alone, and you're putting it into the trust while you're alive. So that's the hard part. That's what I call the sweat equity. The easy part is the assets you buy in the future. And here you buy in the future, when you're buying something, you're buying a new house. You say, hey, we have a trust. And you give them a copy of the trust, and then they put it in the trust. You're opening up a brokerage account somewhere. I want it in the trust name. That's how you do it. It's not hard. Not hard at all. One thing we didn't talk about, I know we're running out of time. There's a special will that has to go with the trust, okay? It's called a pour-over will. And I just want to explain how this works real quick because I know we're running out of time. So remember, if you pass away and we have assets that are in the trust, no problem, everything goes smooth, we're great. But what happens if we have an asset that's like in Andy Rosenberg's name alone, a bank account? We forgot about it. There's no beneficiary, no TOD, no nothing. I have $5,000 in the bank account and I died. Unfortunately, the trust just can't go out and grab it and bring it in. I wish it could. So what happens? We will have to go through all the hassles, delays, expenses of probate court. At the end, the judge is going to say, where does that $5,000 bank account go? In the example I just gave, we look at the will. The will says it gets poured over like a drink into the box. So there's a special will that goes with the trust called a pour-over will. And what it means is, yes, you got to go through probate if the assets are in your name alone, but it guarantees that everything will get poured into the trust and eventually the trust will disperse. Did that make sense?
It does. And I think you've cleaned it up, and we'll leave it there for today, unless there's any final thoughts that you want to share.
Did I bore everybody on this episode, or did we do okay here, Lisa?
No, we did okay. You know, something that comes to mind, Andy, is when I did my trust, they said the only thing that you are worth is the change in your pocket. Everything else needs to be designated to a beneficiary or a trust or something. So I think that's a good frame of reference.
That's a great way. I've never heard someone say that. I like that. I'm going to use that in my workshop. That is a very smart saying, but you are 100% correct.
We'll leave it at that. Hey, folks, thank you so much for listening to If You Don't Plan, You're Stupid. A trust only protects your family if it's actually funded, and getting it right can save months of probate and lots of stress, plenty of money too. If you want to make sure that your trust works the way that it's expected, visit rosenberglawfirm.net to get started. And don't forget to like, subscribe, and follow the show. Maybe even share it with somebody who you know might be doing their trust planning right now. We'll see you next time.
Take care, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.